Dear learners, I welcome you all to this course on understanding human rights. Today, in this lecture, we are going to discuss India and human rights, fundamental rights, and directive principle of state policy. These are the topics that we are going to deal under India and human rights. Then, after that, we will be discussing about the institutional mechanism that India has developed for the promotion and protection of human rights in the country. So, first of all, we are coming to the point what is India's international obligations for human rights. It is very interesting and also very significant to note that Article 51 of the Constitution of India mentions the promotion of international peace, and it states as the state shall endeavor to number one, that is A, promote international peace and security. You see, India, the country, will try to promote international peace and security. It will promote international peace and security. This is a constitutional obligation imposed by the Constitution of India. So, first of all, it will promote international peace and security. B, maintain just and honorable relations between nations. Again, interesting that India's foreign policy will be based on just and honorable relations. It means nothing like that the states will be considered the inferior, small, or weak, or superior. Rather, it will be on the basis of equality. C, foster respect for international law and treaty obligations. Important for the purpose of our topic today, that is, for it is C is saying that India shall endeavor to foster respect for international law and treaty obligations in the dealings of organized peoples with one another, and encourage settlement of international disputes by arbitration. So you see all these clauses, they are talking about what will be India's role in maintaining international peace and security, and also to promote honorable relations with other countries of the world. And thirdly, it is respect for international law and treaty obligations. So, what are treaty obligations of India? All the international treaties that India has signed or India is the party to, that becomes India's international obligations. So, there are many treaties. The treaties may be of different kinds, but here we are basically concerned with what we call international obligations of India, keeping in view what are the international human rights treaties, conventions, declaration India has signed. It is India's constitutional obligation to fulfill its international obligations, as we saw in Article 51 of the Indian Constitution. The United Nations human rights instruments means declarations, covenants, conventions, and treaties recognize member states as the grantor and protector of human rights of people living in their territories. So, it is one India's constitutional obligation that we see that it is we the people of India, of course. When constitution is saying, it means we the people of India have imposed this duty upon the country to respect international law and also fulfill treaty obligation. And on the other hand, you will find when we have signed the UN Charter and we have become the member of the United Nations, then we should also see that what are the responsibilities imposed upon us through UN Charter or other international treaties that we have signed. So you'll find that all the declarations, covenants, conventions, and treaties that India has signed, it is India's international obligation as well as constitutional obligation to respect and fulfill the obligations that have been imposed by those treaties and conventions. It is also interesting to see that United Nations itself is imposing obligations upon the member states to promote, protect human rights in their territories. Again, another important point when we are going to deal with India and human rights, what is to be understood that in international organizations like the United Nations and its organs and specialized agencies have to operate in an interstate framework of international relations. So, we have many international organizations. These international organizations or supranational bodies, they are joined by the member states of the world, different countries of the world, sovereign nations have joined. But we should remember that even the United Nations, a body like United Nations and other international organizations, they have to operate in an interstate framework of international relations. When I am trying to say that it is an international state framework of international relations, what is to be understood that in the international arena there are sovereign nation states, and that's why the sovereign nation states are internally supreme and externally free. So that is why these, the bodies like United Nations, they have to respect the sovereignty of the member states. And therefore, the best example, if you want to understand, for example, the headquarters of the United Nations in New York. So what happens if there is a meeting of the United Nations in New York? It means that a visa is to be taken from the US, United States of America, because without visa you cannot enter into the United States of America, even for attending the meeting of the United Nations. So therefore, it means that the bodies like United Nations, they have to also operate in an interstate framework of international relations. Now we are trying to highlight what are India's international obligations on human rights. So India's international human rights obligations include the international treaties of human rights India has signed or ratified. We cannot discuss all the treaties that India has signed or all the declaration, covenants, conventions, etc. that India has signed, but India has signed many of the important treaties of the United Nations and other, organizations. So, for example, India is a party to the International Bill of Rights and several other UN instruments on human rights. So far, you will find United Nations has adopted more than 100 treaties and conventions, covenants, or declarations of human rights relating to all aspects of human rights, and you will find all the sections it has tried to cover. For example, indigenous people, for example, children, for example, women, minorities, different convention against racial discrimination, etc. all. So India is a party to fairly good number of treaties and conventions that United Nations has adopted. And more importantly, what we have to remember, that International Bill of Rights, that has, the International Bill of Rights means Universal Declaration of Human Rights, then International Covenant on Civil and Political Rights, then we have International Covenant on Economic, Social and Cultural Rights. So these three instruments of human rights, they make what is called International Bill of Rights. India is the party to all these three, treaties or declaration, or one declaration, two treaties of human rights, and that is why India is a party to International Bill of Rights. So therefore, all the treaty obligations that you are seeing, it is whether ICCPR, ICSAR, or even declaration that is there, the UDHR, all these provisions, they are to be respected and they are to be implemented within the country of within the country. So that is why this is India's international obligation. India has been, so far what has happened, that we have signed or ratified many treaties and conventions, but at the same time you will find India has been criticized for not fulfilling many of its international human rights obligations. So, for example, we are a party to ICCPR, International Covenant on Civil and Political Rights, but you will find that the periodic report that India is supposed to, submit in the Human Rights Committee, most of the time it is delayed. So that delay is criticized, that India is not fulfilling its treaty obligation. That is, it should, of course, since 1979, how many reports India has already submitted? That India is supposed to submit, after every 5 years. So that you have to see. So similarly, it means that India is criticized for not fulfilling many of its international human rights obligations. For example, India is a party to Genocide Convention, UN Convention on Genocide. But you will find that there is no corresponding law in the country so far as crime of genocide is concerned. So that is why many human rights organizations have criticized India. This kind of criticism of the different countries of the world you will find by the human rights organizations and activists. So it is not something new that India is being criticized. Many other countries, almost all the countries of the world, they are criticized. But when India has been criticized for not fulfilling or compromising with its international obligations on human rights, at the same time, it has been appreciated for its compliance with many other international human rights treaties. So, on the other hand, India has been appreciated as well for fulfilling its treaty obligations or its compliance with international treaties of human rights that India has signed or ratified. After discussing this, India's international obligations, we are coming to constitutional framework for human rights. As you know, the constitution is the basic document that is set of rules for any country. So, when we are trying to analyze the legal dimension of the human rights in a particular country, we will go through the constitutional provision. So that's why here we are going to discuss the constitutional framework for human rights. It means that what kind of rights have been mentioned in the Constitution of India, what kind of sensitivity towards rights was shown by the framers of the Constitution. Because this was the time when we were framing our Constitution in India. This was the time when the UDHR was also being framed by the United Nations. So, our representative was already there in the United Nations. We have already mentioned that how Hansa Mehta played an important role in making what is called the gender sensitive language of the UDHR. So, therefore, here what we are going to discuss that what is the constitutional framework for human rights in India. As you know that Indian constitution is among the lengthiest written constitution in the world. Indian constitution has been appreciated for being one of the finest constitutions, as well as it is among the lengthiest written constitution in the world. It is important to mention that the Constitutional Assembly of India adopted the constitution on 26 November 1949 and came into force, this constitution of India came into force on 26 January 1950. On the other hand, it should be noted, and it is significant, that the United Nations General Assembly adopted the UDHR on 10 December 1948. So you see, it means that you see the timing. You see the same. This was the time when UNGA was discussing UDHR. We were discussing our own constitution. The UDHR inspired the framers of the Constitution of India to include a comprehensive set of human rights. While discussing the evolution of the concept of human rights, we discussed about UDHR, and we also discussed that UDHR has inspired many countries of the world to include human rights provisions in their constitution. You will find that UDHR had influenced framers of our constitution as well. So, in our constitution, we have a comprehensive set of human rights. The constitution incorporated civil and political rights in part third. Most of the civil and political rights are there in part third, means first generation human rights. And that is why they are the fundamental rights. They have been called fundamental rights. Part third of the Indian Constitution deals with the fundamental rights. Why they are called fundamental rights? Because these rights which have been mentioned in part third of the Indian Constitution, they are basically legally justiciable or legally justifiable. And socio-economic rights, you will find, they have been included in part 4th of the Indian Constitution, that is Directive Principles of State Policy, which is legally not justiciable. So this is the main difference between DPSP, that is Directive Principles of State Policy, and fundamental right. All the fundamental rights, they are legally justiciable. They cannot be taken away. They are inalienable. Whereas here you will find that the rights that are socio-economic rights, they need a lot of resources, and that's why the progressive implementation of these rights will be there. So that is why these rights have not been made legally justiciable. However, they carry a lot of weight, and they are included in part 4th of the Indian Constitution, that is dealing with directive principles of state policy. The Constitution has also included the fundamental duties of citizens. So it is not only rights, the first generation human rights, second generation human rights, even the group rights. You see in the fundamental rights chapter, you will also find group rights. For example, rights of linguistic and religious minorities. That is also there. So that's why you'll find all the generations of rights, they have been included. Now you'll find, interestingly, that India has also included what is called the fundamental duties in the Constitution. Of course, it was added later on, but after all, it is there in the Constitution of India. So, it is a it is to strike a balance between rights and duties. While discussing the Western and non-Western perspective of human rights, we pointed out that the human rights paradigm of the West, a Western perspective of human rights, is rights based or rights centering to some extent. Whereas you will find that the non-Western traditions of human rights are basically duty-based traditions, where the duties, responsibilities, they have been emphasized more in comparison to rights. So that is why what has happened, that when the fundamental duties was also included in the Constitution of India, first of all, it is reflecting what we have been pointing out, that the non-Western tradition is duty-based tradition. So that is why the duties have been included at the same time. So when we have fundamental rights and as well as duties, it means that the Constitution has tried to strike a balance between rights and duties. It is also important to mention that while explaining the nature of human rights, it was discussed that rights and duties go together. We discussed that the rights and duties go together, and that realization was there, and this is the reason that it has been included. The fundamental duties have been also included in the Constitution of India. Now we are going to discuss the constitutional provisions of human rights, and it will of course take a lot of time, so we will not wind up in this lecture only. We will continue in the next lecture also, so far as the constitutional provisions of human rights are concerned. The human rights in Indian Constitution are derived from the following provisions. What are these? Number one, the preamble of the Indian Constitution. Number two, the fundamental rights. Number three, the directive principles of state policy. And number four, other provisions of the Constitution that we can discuss later on. The preamble. The preamble of the Indian Constitution, which is of course important from the perspective of, it is because it is mentioning the philosophy, spirit, and the principles of the Constitution. So that is why it starts, the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. So, first of all, you see what the people of India, they have decided to do. They have declared their country to be a sovereign, socialist, secular, democratic republic. That is one thing that should be kept in mind. And it proclaims justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship. So you'll find social, economic, and political justice that has been proclaimed. Then also liberty of thought, expression, belief, faith, and worship. Equality of status and opportunity that has been also ensured through this preamble. And to promote among them all means among the people of India, fraternity. The fraternity is also there. So the liberty, equality, fraternity that was there in the French Revolution, you will find that is there, very much there in our preamble as well. So fraternity assuring the dignity of the individual and the unity and integrity of the nation. After that, it is mentioned that in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So this has been mentioned. The preamble, when we see this preamble, we have already mentioned from the Constitution of India as it is. So the preamble sets out the Constitution's basic spirit, principles, objectives, purposes, and philosophy. It is a guide to interpreting the provisions of the Constitution. This is the significance of the preamble. So they are not dead letters, rather they carry a lot of weight. And that's why the preamble sets out the Constitution's basic spirit, principles, objectives, purposes, and philosophy. And it is a guide to interpret the Constitution of India. Now, very interesting, and for which the Indian judiciary should be appreciated, and that is the preamble and the doctrine of basic structures. Indian judiciary, especially the Supreme Court of India, has been appreciated for expanding the horizon of rights. And some of its judgments, they have been, appreciated all over the world. One of the best thing that you'll find, the doctrine of basic structure is one of the classic examples of judicial innovation to preserve the spirit of the constitution. This is India's, India's judiciary's significant contribution to, to the country. That is doctrine of the basic structure that was innovated by our judiciary. Although it is not mentioned, by it we mean the basic structures. This term is nowhere in the constitution. In the constitution, it has not been mentioned, but you will find, it is the Supreme Court of India, through its various judgments, it has developed this doctrine. Although it is not mentioned anywhere in the constitution, it has helped the judiciary to promote and protect human rights of the people and aims and objects of the constitution. So, this is judicial innovation, but because of this doctrine of basic structures, what has happened? That judiciary has become more powerful in protecting and promoting human rights of the people, and also, also maintaining the very spirit of the Constitution of India. So that is why this basic structure doctrine is very, very significant, very important from this point of view. The Supreme Court in the Keshav Nanda Bharti case that was determined in 1973, before that there was Golaknath case was also there. Several other cases are there. So the Supreme Court in the Keshav Nanda Bharti case 1973 and several other landmark cases outlined the basic structure of the Constitution. The basic structures of the Constitution, and what are these basic structures? They include, besides supremacy of the Constitution, first of all, you see that what has been outlined by the Supreme Court of India, that in the country there is nothing like supremacy of parliament or anything like that. Rather, what is supreme in the country? It is supreme is the Constitution of India. So, our parliamentary system of government, it is said that in a parliamentary form of government, there is supremacy of parliament, as we see in the case of England, UK, where you will find parliament is supreme. So we have borrowed parliamentary form of government from England. So that is why it is said, most of the time people get confused that Indian parliament is also supreme. No, it is wrong to say that Indian parliament is supreme. What is supreme? Unlike British government, unlike the British system of governance, in our country it is constitution which is supreme. So the supremacy of constitution is there rather than supremacy of parliament. Because when we discuss the supremacy of parliament, so in England you will find it is said, it was said, of course, now it is possible, that the British parliament can do anything except to make a man a woman a man. That was the observation that was made when the medical science was not very advanced. If you apply this statement today, you can say it can do anything, even it can make a man a woman a man. So therefore, that kind of supremacy of parliament is not there in our country. Rather, what has been, what has been ruled by the Supreme Court of India, that the constitution will be supreme. So in our country, we have supremacy of constitution. So besides supremacy of the constitution, we have sovereignty and unity of India. What are the basic structures? So first of all, supremacy of the constitution. Then we have sovereignty and unity of India. Its democratic, republican, secular and federal character. These are also basic structures. Democratic, republican, secular and federal character. Individual freedom and fundamental rights, etc. From our point of view, this is important. So what the Supreme Court of India has done, it has identified basic structures of the Indian Constitution. These basic structures are those structures which cannot be amended by the Parliament of India. So it is not like British Parliament which can make or unmake any law. In our country, it is not possible. The basic structures of the Indian Constitution cannot be amended by the Parliament of India. Now, what is the significance of the basic structures doctrine? The basic structure doctrine has helped the judiciary to save citizens from legislative overreach. It may happen that a particular political party or few political party with what is called the majority in the parliament, some kind of absolute majority in the parliament of India, can impose its or their will upon the citizens. So that is why, and they can try to, or they can toy with the idea of changing the constitution or the very spirit of the constitution through successive amendments. Keeping in view, the Supreme Court of India has come with the basic structure doctrine, and you'll find that the Parliament of India can make or unmake any law except to change the basic structure of the Indian Constitution. It cannot change. So that is why the legislative overreach that can be anticipated with the absolute or brutal majority of one political party or many other political parties, if they are forming coalition, then what is there, that they cannot change the basic structure of the Indian Constitution. And it has also protected citizens from executive tyranny. Not only legislative overreach, but also executive tyranny. And it has helped Supreme Court to function as the custodian of rights and liberties of people. Supreme Court of India is, or the judiciary in India, is the custodian of the rights and liberties of the people. So, how Supreme Court has been able to protect the rights and protects the rights and claims of the people through these basic structures of the Indian Constitution, and that is why, because this is their what we call the custodian of the rights and liberties of people. Again, Supreme Court of India is also the guardian of the Constitution. Guardian is to be also protected, how it is being interpreted. And while interpreting the various provisions of the Constitution or the spirit of the Constitution, the prenatal history or the final interpretation of the Constitution will be made by the judiciary, not by the legislature or executive. So that is why, because of this, you can understand the significance of the basic structures doctrine, especially from the perspective of the promotion and protection of human rights and liberties of the people in the country. Now we are coming to the fundamental rights. So the fundamental rights are those rights which have been declared as fundamental and inalienable by the Constitution. So what are fundamental rights? The rights that have been mentioned as fundamental and inalienable in the Constitution of India. They are in the part 3rd of the Indian Constitution. Fundamental rights include, the number 1, right to equality. You will find Articles 14 to 18, they are trying to ensure various dimensions of equality in the country. The right to freedom, Articles 19 to 22. Then the right against exploitation, Article 23, 24. This is also important, why these kind of rights are there, right against exploitation. Then the right of freedom of religion. You see, India is a diverse country, it's a multi-religious country. So that is why it is also ensuring the right to freedom of religion. That is Articles 25 to 28. Then we have cultural and educational rights. The cultural and educational rights of all citizens, as well as the specific rights of minorities, linguistic and religious minorities, to establish and administer educational institution of their choice. And lastly, and the most important, is the right to constitutional remedies. That is Article 32. The father of the Indian Constitution, Dr. Ambedkar, stated that the right to constitutional remedies is the heart and soul of the Indian Constitution. The significance of Article 32. The 5 writs that can be issued by the judiciary, by the court, that is so important. What has been observed by Dr. Ambedkar, that they are heart and soul of the Indian Constitution. It means that these 5 writs that the Supreme Court of India or the High Court they can issue, or the judiciary can issue. Why this is important? Because all other rights, if they are infringed upon, if they are taken away, if there is any kind of encroachment upon the rights of the people, either by the legislature or by the executive, then people can directly go to the court and the court will issue the writs. and the writs is for the protection of the rights of the people. So therefore, all these rights that are declared as fundamental, they will be meaningless if if these writs are not there. That is right to constitutional remedies. And therefore, Dr. B.R. Ambedkar, who was the chairman of the drafting committee of the Constitution and who is also regarded as the father of the Indian Constitution, rightly observed that right to constitutional remedies are the heart and soul of the Constitution. Before we deal with the provisions of the Constitution dealing with human rights, it is pertinent to point out that all fundamental rights are human rights. But not all human rights are fundamental rights. So human rights can be a bigger circle within which you can find in the inner circle fundamental rights. So all fundamental rights come under human rights, but all human rights, they do not come under fundamental rights. So the fundamental rights are those rights which have been declared as fundamental, basic, and they are legally justiciable. They cannot be taken away. They are inalienable. So that's why they are fundamental rights. So all human rights are not what we call fundamental rights, but all fundamental rights are, of course, human rights. There are several human rights that are not declared as fundamental in the Constitution, and they are included in some other parts, like the directive principle of state policy, or at several other places you will find the mention of some kind of rights are there that we will discuss in the coming lectures. We will discuss those rights in other lectures, of course. Right now we are going to discuss the fundamental rights. So with this I am going to conclude this lecture, and we are meeting in the next lecture to deal with the provisions of the Constitution. The provisions of the Constitution under Part 3rd of the Indian Constitution, and they are dealing with the fundamental rights. So all the fundamental rights we will be discussing in the next lecture. Thank you very much.